don't mind, if you understand where I'm going, making the decision and getting stuck with it, but I don't want to get stuck with decisions that I never made.
Is now in session on, Mr. Williams presiding. Please be seated.
Thank you, ma'am, and good morning, everyone. Let's go ahead and set forth our appearances for the record. We'll start first with the plaintiff, then we'll move to the defense.
Good morning, Your Honor. Joe Neal for UNFI, together with my colleagues Nick Hoffman and David Spurlock.
Good morning, Your Honor. Joel Odou on behalf of Water Inc. and Infinity Lifestyles.com.
Morning, Your Honor. Scott Rasmussen on behalf of Hanna Instruments.
Morning, Your Honor. Rob Rollins on behalf of Milwaukee Instruments.
Morning, Your Honor. Jim Kavanaugh, Gordon Reeves in Las Vegas, here on behalf of third-party defendant, Real Water Tennessee, LLC.
Was that good, all appearances? I don't know what we're looking at. Okay, once again, good morning. And I guess we have to continue our journey, right? And next up is a motion on the
Number 18, Your Honor.
18. Yeah, all right. So,
Good morning, Your Honor. Nicholas Hoffman for UNFW.
Motion, sir.
Good morning. UNFW's motion limit number 18 now transitions from the fact motions in limine to an expert motion in limine. This one has to do with only one of plaintiff's experts, an expert named Michael Freeman. Mr. Freeman describes himself as a forensic consultant, epidemiologist, and a biomechanical expert. He also describes himself as a medico-legal consultant who has provided testimony in more than 400 civil and criminal trials in state and federal courts throughout the United States. And that's in his report, which is Exhibit A to our motion. A significant portion of Dr. Freeman's testifying practices in car accident crashes. So he acts as a biomechanical expert in car accident crashes, including in criminal trials, and he considers himself to be an expert in car accident analysis. Your Honor, I'm going to show you, but we're essentially moving to exclude a portion of Dr. Freeman's testimony on two separate grounds. And in order to explain those, I need to go over what epidemiology is.
I mean, I understand that you can make a record, but I think you should address it from this perspective, because at the end of the day, whether they can testify, the issue is whether he meets the qualifications requirement.
You're right, Your Honor, and that's what I'm transitioning into now. So I'll go quicker through this, but this is directly from Dr. Freeman's report. He explains that epidemiology is essentially the scientific study of the cause of disease and injury in populations. So he's looking at it from the broad sense of looking at statistics, seeing how certain injuries could be caused across different populations.
Now, here's my next question. What are his credentials?
So I'm going to have a slide on that, and I'm happy to skip ahead. He is not a medical doctor. He does not have a medical license in the United States. He has no clinical experience whatsoever as a medical doctor in the United States. He also has no experience whatsoever in diagnosing any of the injuries or diseases at play here from a clinical perspective. So, for instance, he has no hepatology experience. He has no credentials of any kind that would allow him to diagnose a liver injury, acute non-viral hepatitis, or any of those types of injuries that are alleged by plaintiffs in this case.
All right. But what are his credentials, once again?
Let me skip ahead to that, Your Honor. So, obviously, our first ground is the credentials, and I know Your Honor knows Hallmark well, so I'll skip past those slides. But here are his specific credentials, which I've copied and pasted directly from his report.
Right.
I do want to specifically highlight and underline something that's going to be very important. And you'll see there about the fourth line, he starts going through his relevant academic degrees. And the first one he says is a Doctor of Medicine degree from Umeå University, that's in Sweden. And that's very important. I'm going to highlight that because I'm going to show you what that means in Sweden. So other than that, his credentials all relate to a PhD in epidemiology. He has a master's degree in epidemiology. He has no sort of medical degree, as we use that term in the United States.
But what is a Doctor of Medicine, med-dr?
Let
I mean,
me,
I understand Umeå University, it's my understanding.
Yep.
It's a global university, so it's recognized and accredited. I get that they're from Sweden. I don't understand, I don't mind saying this, Sweden's system as far as medical training for doctors. I have a general sense, not everyone, not every university follows or even countries follows the exact same model. In fact, here in the United States, we have two competing models with the MD and the DO.
yes.
I understand that. And so that's what I'm trying to figure out, what his training is, because I'm not 100% sure.
Yep, and I'm going to show you that. So that's why I highlight this med.dr degree from this Swedish university. It is undisputed that is not a medical degree, as we use the term in the United States. So, and I want to show you, for instance, Dr. Freeman, as we'll refer to him as doctor nonetheless, he has been excluded repeatedly and routinely across courts across the United States for exactly this ground. So, this is from Adams versus Piedmont Henry Hospital. It's a Georgia published appellate case, 365 Georgia App 257. This is a 2022 case. It just came out. And it's, quote, as Dr. Freeman clarified in his deposition, a doctor of medicine in Sweden is akin to a PhD in medicine here in the United States. The degree is not designed to allow him to become a medical practitioner in a clinical setting. The degree is a research degree, end quote. And this was affirming an order excluding the testimony of Dr. Freeman, concluding that while he is qualified as an expert in forensic epidemiology, he is not qualified to provide medical causation opinions. Your Honor, here's yet another case. So this is Taylor versus Royal Caribbean Cruises. We have
If it's not published, I'm not going to read it.
Understood.
So it's a general rule. I don't read published decisions.
Understood. And we have the various sites in our papers, both our motion and reply. Again, I don't think we necessarily need to read it, but the key.
But I'm curious about the other one. Here's my question. I don't know this for sure. I don't even know if this was developed in his deposition regarding his testimony. It says here that it's akin to a PhD, but it's my understanding that this doctor of medicine, or whatever it is from Sweden, is actually a higher level than a PhD. I mean, that's just from what I read, because I don't mind telling you this. I did my own independent research, because I don't know what this is. I don't. And they say typically most people don't get them until they reach the age of 40. Something to that effect. I'm just looking at it from a historical perspective. I don't know if that's true or not. Was that delved in his deposition? What rigorous course you go through? And I don't mind telling you for two reasons why I did this. First of all, understand this. This is Nevada. We follow the Williams case. Specifically in the Williams case, I made a determination to exclude a nurse from testifying, RN, who was published, had been peer-reviewed, and all those things. And it actually was, I think maybe a clinical, or I forget exactly what the training was. And I excluded him. Then I remember reading it, and I was affirmed on that issue, but I remember reading the decision and what Justice Hardesty said. I've read the decision in over a year, but I remember these decisions. That's why I don't read unpublished decisions, because I don't want to, why worry about that? I'm focusing on published decisions. And what Hardesty said was this, and it's in there, you can pull it. But I know what he said. He said, look, I'm not going to have a bright line exclusion of a nurse. And he made an example for like Tennessee, I think it was a reference to when you looked at the case there. He said it just depends on the training. And so here's my question. What are this degree, what does it do? I mean, I don't know. I have no clue. And so when I reviewed the points of authorities, I don't mind saying it. I mean, I don't know what goes on. Because I had to have some sort of foundation as far as the degree is concerned. And I still don't know a whole lot about what they do. I know it's a fairly rigorous course. And then I don't know what types of degrees UMEA University issues, just as important too. I did have a question, and I said to myself, well, from this university, can you practice medicine in the United States, right? And so I just did a Google research, and I did pull something up from the University College of Medicine. And I don't know why they did this, I have no clue. But they just had a list of medical schools recognized by the state of California from the different countries. And I go down and look, Sweden, University of UMEA Faculty of Medicine. I have no clue what that means, but, you know, I need to know, what does that mean?
So, Your Honor, and to be clear, I think it's undisputed, we'll wait until plaintiffs get up, but it's undisputed that he does not have a medical degree that can be used in the United States. And if I could read just briefly from his deposition, this is our Exhibit B.
No, go ahead, and I want to slow down because I want to follow you there.
Okay. This is our Exhibit B, and I'm going to read from page 9 of the deposition,
Okay, let me,
lines 23 to 25.
okay, I'm there with you.
So, Your Honor, when he described during the introduction what
Wait, which line are you at?
I'm gonna read 23 to 25.
Okay, which line are you starting at?
23. So this
Page
is
23, which line?
page 9, line 23.
Okay.
Sorry about that if I wasn't clear.
No, that's okay. I'm gonna follow you.
So page 9, and I'm going by the numbering of the deposition.
I'm not following you, I'm on page 9, which line are you at?
23 to 25. And this is Dr. Freeman testifying. He says, quote, "I don't do anything that requires a license in medicine, but I do all sorts of things that don't require a license." And so he explained, and I agree, I wasn't at this deposition, I don't think that they went to the level of depth of some of these other cases where he's been routinely excluded and explains. And in these other cases, you'll see that they also sometimes hold evidentiary hearings and he's excluded, and other times they ask for an affidavit from him and he explains that he can't practice medicine in the United States and that he can't do anything that requires a medical license in the United States. But all the evidence before the court, including his own deposition testimony, explains that he cannot offer opinions that require a license in medicine. Now, I'll grant you, I don't think that he understands where that demarcation is, but I think it's very clear from his testimony that, even he concedes he is not authorized to do anything that requires a medical license in the United States. And so, Your Honor, everything that I've seen for this UMEA University degree, med.br, is that it's essentially a PhD here in the United States. It does not rise to the level of an actual medical doctor in the United States. And in any event, it certainly does not authorize or allow him to practice medicine in the United States. And I think it's undisputed that he never has practiced medicine in the United States. So if we could go back to the PowerPoint. And the other thing I think he was clear about is that he does not have any sort of clinical medical degree, or what we would refer to as an MD in the United States. He has essentially what is a research degree. So he does not have any sort of license that allows him to make a clinical diagnosis of any sort of injury, much less a specific sort of injury such as a liver injury or the like. And this is why the bulk of Dr. Freeman's expert work relates to his biomechanical experience. And I know that the court is familiar with the distinction there. I did see there was a case that, I guess first I'll go to Williams, which I know the court was involved in. And obviously, you know this well, I won't spend a lot of time on it, but, Williams, 127, Nevada, 518, this is specifically at sites 528 to 529. I think Your Honor excluded Nurse Hambrick, because Nurse Hambrick had little, if any, experience in diagnosing the cause of hepatitis C. Obviously, this was upheld on appeal, and at the bottom there of this quote, the Supreme Court of Nevada recognized that Nurse Hambrick, quote, does not possess the requisite skill, knowledge, or experience to testify as an expert witness regarding the medical cause of hepatitis C transmission at ECSN, end quote. And one of the key things there was that Nurse Hambrick, while having this nursing license, was not a medical doctor. Was not qualified to testify regarding medical causation. Your Honor, we do believe that Dr. Freeman, it falls squarely within this analysis. So Dr. Freeman does not have any sort of clinical medical degree. Yes, he has some sort of Swedish degree that is, tangential perhaps to medicine. It's a research degree, but that is exactly what the issue was with Nurse Hambrick. And for Williams, this case, we definitely believe that Dr. Freeman needs to be excluded from testifying on medical causation issues. The other case that I mentioned, Your Honor, was this case of Manhus versus Tinker, and I came across it. This is a Supreme Court of Nevada case. I know it mentioned that it came from Your Honor in the trial court. And the issue here was about what a biomechanical...
Is it published?
It was 488 P. 3rd 578 was the site to it. I don't know if it was an official register. It was I did note it was a Nevada Supreme Court case.
Right, because I don't remember this case. Is this a case that was sent up from the short trial program?
It was. It
It wasn't my case.
Okay, you were mentioning it.
That's the problem I have with the short trial program. I don't mind saying this. I have a big problem with this one aspect of it. That was a short trial case, right? I didn't handle the case. For whatever reason, based upon the way they do the record here, it's assigned to me. It's not my case. I'll say it for the record, that's not my case.
I'll go.
And I don't even think this was actually a formal published decision. I might be wrong on that, but once again, it was not my case. So if anyone refers to it out there, this is Judge Williams ruled in this case. I did not rule in this case. This case, I was only named in this case because it was a short trial case in Department 16.
Your Honor, when we get cases as arbitrators, and I'm on an arbitration list, I get cases constantly, as you know.
Yeah.
That are under $50,000 cases.
Right.
We try them in arbitration,
Or the short trial program.
and then they go up to the short trial program if they don't like my ruling, right? And then that's where, but for lack of a better word, you just happen to be in Department 16, and that's where it's assigned to.
Yeah, and see, this is a
Not
little
yours.
different because this was a short trial case.
Understood.
And so that goes straight from the short trial up top.
Agreed.
And so, and I'll be candid with everyone, I don't mind saying this, that's why I think in a short trial, they should have some sort of immediate appeal within a certain time period, maybe limited to a minor number of issues, where you can run to the trial court and get a decision real quick as to whether the short trial judge made the appropriate decision or not. Then, yeah, the trial court should get stuck with it. That's a slightly different procedural.
Well, we can bring that up at the bench bar meeting.
Absolutely, bring it up to the Supreme Court, because that case still bothers me.
So, Your Honor,
I don't mind saying, I don't mind, if you understand where I'm going, making the decision and getting stuck with it, but I don't want to get stuck with decisions that I never made, and that's basically the problem. And sir, I apologize.
oh, no need to apologize, so.
That's a real sore spot with me.
So I'm gonna skip over that case. The one thing I would mention is and I know that we had prior discussions about this, and we also, each party submitted bench briefs on this issue of causation. This issue really falls within the general causation versus specific causation analysis. And that's what, that case got into with the Supreme Court, and they were explaining that essentially like a biomechanical expert can testify about general causation, the forces that may happen from an accident, but can't get into, specific medical causation.
I
about-
don't think they can. I don't mind saying that, that's what the
Yes.
case stands for. But at the end of the day, they're given a probability of injury opinion, which is slightly different. But that's another day, another discussion.
Yes.
Let's come back to this case here.
Yes.
Because, I need to be educated on specifically what what the training is in Sweden, as far as this is concerned, because, and the reason why I say that, I just don't know. I don't know. And I was trying to go through the effort to get a little bit of handle on it before I hit the bench today.
Yes, Your Honor, and I don't think that there's that level of detail in his deposition, but I think the one thing that's very, very clear, and that I can say very resolutely, and, I'll invite plaintiffs to disagree when they get up here, is that he does not have training that allows him to perform any sort of clinical practice, or that allows him to do any sort of clinical medicine. I believe that's true in both Sweden, it's certainly true in the United States. So he is not qualified in the United States, as is required by Hallmark and as is required by the Williams case, to do any sort of clinical diagnosis or anything like that. And so that in and of itself disqualifies him from providing expert testimony on medical causation, as Williams explained. So, that's clear from page 9 of his deposition that I just read. It's also clear from, the other published decision that I mentioned, where they explain that, what he had in Sweden was not a medical degree, as we call it here. It's not something that qualifies him to do any sort of clinical practice here. So I'm happy to discuss that further, Your Honor. I don't believe, and I did, by the way, print out an entire copy of his deposition in case you wanted it. I know you've been asking for those. But, and I'll invite, when they get up, plaintiffs to point out any sort of evidence we have that he is allowed to practice medicine in the United States, but there simply is not any. I do, if you're okay with it, want to go on to the second ground.
No, sir, I want you to make a record.
Okay. So the only other thing I guess I'd say about this first ground, Your Honor, is, I do want to just touch briefly on general causation versus specific causation. So general causation, and this has all been briefed now, and Your Honor, I know plaintiffs 2 weeks ago suggested that only general causation was necessary, and I think in Mr. Kemp's words, that was it. But I did note from their brief that they submitted, they do now concede that general causation and specific causation are both needed to prove causation in a case. So here, Your Honor.
But does it really come down to for what purpose is being offered? And the reason why I brought that up, and I don't mind telling you, everyone, this, one of the problems with being a trial judge is sometimes you just don't have enough time. But yesterday, I really appreciated my time off because I actually reviewed a lot of the points of authorities. And for example, I came up with some thoughts, and I think it's important to point this out because I went back and I looked at the Harley-Davidson case, and what was the other case after that? That was, but I think
Krause versus Little?
Krause. And because I listen to lawyers, I don't mind telling you this. And for example, I think before we departed, Mr. Neal stood up and said, "Well, Judge, you're letting everything in, right?" And I thought about the record in this case, and I think implicitly in the record, there's a reason why I made some of my decisions as far as, and I think in the, what was the case involving Ford Motor?
Trejo?
No, I got them all here. Actually had them all. Oh, and Krause, right? And I was thinking about it. I looked at Krause and I looked at Harley-Davidson, and like, and I don't mind telling everybody this, I came up with some factors that I think are consistent all the way through as to my decisions as it relates to similar events. And I don't mind telling you why I did that was, and I looked at Krause, and one of the issues in Krause was essentially this, because when I looked at the decision, and we'll get to this a little later, they had a section similar accidents, right? And that was based upon, the latter accidents. Well, that was a design defect case. This case is slightly different. This is a manufacturing defect case. And so I think in order to have some sort of guidelines I could be guided by, I called it similar events, right? And I'll go through that, but that's another issue. But I thought about all those types of things, and from a consistency perspective, I think it's important somewhere down the road for any decision I make that in lieu of saying arbitrary capricious, at least the reviewing court should say, okay, what was Judge Williams thinking when he makes these decisions, and whether he was correct or not. But we won't go there yet. Let's go back to the general causation versus specific causation, because I'm just wondering what impact does that have in this case, because, and this is kind of where I'm going. Clearly, when it comes to plaintiffs' claims for relief, we follow traditional Nevada law, right, as far as their claims are concerned, and we understand what those are. Those are, you know, a doctor has to opine to a reasonable degree of medical probability, et cetera, in a general sense. And so we have this general causation versus specific causation discussion. Here's my point. When it comes to similar events, what is the standard? Remember I asked you that question, what should I rely upon? Remember?
I do.
Right?
I do.
And to this day, nobody's given me or told me exactly what I should rely upon, right?
Yes, so, and I'm,
And so,
I'm-
so what does that come under? Is that under the general causation heading, or?
no, it's not, Your Honor. So for an event that does not involve a plaintiff in this case, so if this is a non-party, it's a third party, and essentially what plaintiffs are trying to do is introduce these third-party other incidents
No, I get that.
in
That's
order
what-
to show their case.
Right, well, they're introducing that for the purpose to establish by circumstantial evidence that this was a defect.
Yes, so they're trying to establish causation in this case. So you would not analyze those third-party cases under any rubric of consumer expectation or design defect or anything like that. What you need to do is analyze those in the rubric of admissibility with, and I'll use the term substantial similarity. If Your Honor believes that it's similarity now, I think that that's a little bit of a, I guess
That might be
that's,
semantics, I don't know if it really matters.
yes. So
Because I have a 4 or 5 part factor that I rely upon. The first would be nexus, right? There has to be a nexus. And what I mean by that, focusing on the product.
So in any event, the rubric for that, I agree on similarity versus substantial similarity. In any event, the rubric is not to look at it and see if an ordinary consumer in that case, that third-party incident, could have brought a claim and could have succeeded for design defect or manufacturing defect. The question is whether these plaintiffs have close enough allegations that they're alleging here, such that this third-party evidence, which normally would not be allowed, should be allowed to be used as circumstantial evidence of their own injuries. So,
I think actually it's slightly different. I kind of read the cases as being circumstantial evidence of a defect. Right? So that's a little different, right? That's a different analysis.
I don't think necessarily, in any
Because,
event.
no, it's a big deal, because if we go to Krauss, right? And what do we take from Krauss? Because remember this, there's not a lot there factually, but what can I, as far as decisions made by the Supreme Court, but I can imply a lot of things that based upon their decision making, because first they talk about similar accidents, right? And so I expanded that slightly because I think that can be a little misleading. I think should be similar events, because, for example, in this case, we don't really have accidents. We have individuals who allegedly ingested real water, right? That's not an accident, that's an event. I think events cover both like a injury accident or ingestion of a allegedly tainted product, right? So I call it similar events, but what else did they do in Krauss? Because I know this was your case.
Yeah, so Your Honor, I think the big takeaway from Krauss, and I also want to say the big takeaway from Andrews, which is along the same lines, is that, unlike the court's ruling in this case, which allows all of the other incidents that involve real water, in Krause, for instance, you see that the Supreme Court found that it was correct that one of those was excluded because even though it involved a ladder and presumably involved an injury with the ladder, it was not similar enough. But
they let in the event regarding the ladder where the plaintiff didn't know whether or not their knee hit the lever, number one. Secondly, because this goes to the factors I've been considering implicitly, they don't even discuss the injuries, do they? I would anticipate that they are orthopedic in nature or maybe closed head injuries. We don't know, right?
I think that's a fair assumption. And I would just note that here, 14 of the other complaints did not involve any injury. So, to Mr. Neal's point that he made last week, part of this analysis has to be the injury and the mechanism of injury and whether it's
I'll
close
handle
enough.
that, but we're not talking about mechanism of injury, we're talking about ingesting real water.
Well, that still involves a mechanism of injury. So here, the allegation is it's the hydrazine and it causes this liver issue with them. And that still is what, I would refer to as a mechanism of injury.
No, that's how you fall, how you hurt yourself. I mean, I understand that.
Yeah.
But my point is, and this is what I think this is a really important issue, I do. Because I'm looking at general causation versus specific causation. I understand where it comes from in toxic torts, but we're talking about causation as relates to the injury suffered by the plaintiffs in this case. Then on the other side, out there, you have similar events. That's what I call it, similar events. And like the first issue I thought about was, is there a nexus between the similar events and the product at issue?
Your Honor, I think that would always be the case for other incident evidence. So for instance, for the Harley-Davidson case.
But that's kind of my point. Isn't that implicit one of the factors the Supreme Court had to look at, right? You had to be on a Harley or you had to be on the lever, right?
Yeah, so Your Honor, in the Harley case, just as one example, obviously we know there are tons of accidents and injuries involving Harley-Davidsons, and I think it is telling that the Nevada Supreme Court only found that one was substantially similar. That was the only one that was allowed in that trial because everything else was similar enough.
But you see, here's the thing, and you're saying thousands, but we don't know that. You're assuming things, right? We just know what was presented to the trial court, and that's kind of my point. Here we know, like in the case involving Krause, we know there were accidents regarding the ladder question issue, right? And it was an issue regarding the design defect, right? We get that. Regarding the lever. And one of the individuals didn't even know whether I'll be real specific as to what they said. So I think I got Krause right here. I'm not going to guess. Let me see here. Because we have a lot to talk about.
Yes, Your Honor. I do think that this is a little bit outside of this motion, but I agree that it's important.
Oh, yeah, we do. Because in Krause, it's my recollection. Oh, yeah, here we go. Yeah, this is what our Nevada Supreme Court said further. We are of the opinion that the Bloomquist deposition probably should have been admitted as evidence of a substantially similar accident, period. Bloomquist was injured as he descended his ladder. And although he did not state that he actually touched the release lever, the jury could reasonably draw this inference, period, close. Right, that's straight out of it. So what does that mean? What's implicit in that determination?
So, Your Honor, I think two important implicit factors there to me are, number one, it's not hearsay because it's a direct deposition testimony from an individual. So a lot of the ones that we sought to exclude last week, including, I know the court is still looking at Mr. Pham, that is directly hearsay, but a lot of the other ones also are hearsay. Here, it was not hearsay. So the court moved on to substantial similarity.
Okay,
The next one.
But no, here's my point.
Yep.
For example, and this is straight out of Harley-Davidson, the minor differences between similar events and the instant case do not warrant exclusion, right? Why shouldn't that be a factor I should consider?
It absolutely should be a factor, Your Honor. So in that Harley Davidson case, they had the same injury, they were driving the same miles per hour, they both crashed into the back of a car, and the clip on the allegedly defective clip on the gas tank came undone on both of them. That was the similarity analysis there. And here, as we explained, there are very distinctive differences.
But didn't the Nevada Supreme Court state in Harley Davidson minor differences between the similar events and the incident case do not warrant exclusion?
Yes, Your Honor.
Didn't they say that?
Yes, we don't believe that the differences here are minor in any way. We don't believe that, for instance.
That's okay,
Yep.
but it's not, you gotta understand this. That's okay. You don't have to agree with my decision, right? But I think it's important when it comes to what I call the similar events. I have to tell the Supreme Court, why are you doing what you're doing, Judge Williams? Because right now, the record is kind of, it's not clear as I would like it. I mean, implicit, we talked about a lot of different things, is my recollection. We talked about, for example, ingesting real water. That came up, right? And that would go to the nexus issue. The next issue, and I know we talked about this, but what would the category be? Whether the evidence is relevant to plaintiff's claims to relief. And this goes clear to the heart of some of our discussions, because didn't we discuss quality assurance, quality control, and lack thereof? Would that be relevant to a, quote, claim for defective product unreasonably dangerous based upon a problem in the manufacturing of the product, the manufacturing defects, right?
But Your Honor, other alleged manufacturing defects that are not alleged in this case are not relevant for this claim. So
I kind of get it, but I'm just telling you what my standards are, right? Because the Supreme
Understood.
Court's going to want to look at this. I'm just telling you. And here's the thing. I don't think the harm has to be exact. I don't. But, and I even thought about this. I don't mind telling everybody this. I put a lot of thought into this. For example, when you talk about the type of harm, I thought about it. I said, well, foreseeability. But I said, no, you know what? Let's follow what our Nevada Supreme Court said regarding Prosser and what happened in a recent case by Justice Stiglitz. She doesn't want negligence concepts to come into a strict products liability case, right? And so what's wrong with this? The type of harm could have resulted from the defect, right? You fall, you break your ankle, you fall, you suffer closed head injury. In this case, it would be the type of harm resulting from the ingestion of the chemical at issue. Right, type of harm. We're talking about similar events, right?
So Your Honor, the point I would make on that note is, as we explained last week, a lot of those complaints they involve like styrofoam.
And I'm telling everybody this. This will be in a minute order. You don't have to write it down. I'm just letting you know what I'm thinking of, right? And, but go ahead, sir.
I was just noting that, by that analysis the court just gave,
That's not the end of my analysis, though. I was going to tell you that.
I completely understand. By those comments, obviously, a lot of the other incidents that we showed the court last week involved things that could not possibly have dealt with alleged consumption of hydrazine in water. So they dealt with like styrofoam, or they dealt with an unsealed bottle, or they dealt with a manufacturing issue with the bottling machine where there was some preform that hadn't formed correctly. Obviously, it's our position. I think we made it clear last week, so I won't really get it. But
well, that's
yeah.
what we were discussing, the manufacturing defect issue and quality control, right? I think I brought that up. But I haven't made a decision on all those. But I will. That's probably the best way to say it. And I will tell the court why I ruled the way it did, And I'll just conclude with that as far as, because I thought about these things. Similar events are supported by direct and or circumstantial evidence, right? And I think there's clear evidence of that as a standard. And last but not least, a jury could reasonably draw an inference that the product defect occurred. And I'm gonna put all this in a minute order. But in fact, I got a long, detailed minute order ready to go. I just gotta review it.
Understood, Your Honor.
But getting back to this here,
Okay,
why should this general causation versus specific causation as it relates to this case? What should I do with that?
This,
Give me guidance.
so Your Honor, this matters because of, and I'm putting this up because of this specific witness. Who this witness is an epidemiologist, which we all know epidemiology, biomechanics go to general causation, and biomechanical engineer and an epidemiologist who's not licensed as a clinical doctor cannot give diagnoses. So, Your Honor, that distinction is the exact distinction that applies to Dr. Freeman in this case. So, general causation is
You're saying, look, Judge, he would come under that general causation rubric, but not the specific causation?
comes under general causation. And I'm going to show, Your Honor, that in the Nevada case law. But, general causation, I'm not going to belabor the point, but is X capable of causing a disease? Hypothetically, is it capable?
And that's under that general causation?
That's under general causation.
I'm
So
fine.
could smoking cause lung cancer? Could consumption of real water cause liver failure? Specific causation is, did X cause Y in plaintiff that's before the court? So did smoking cause lung cancer in a specific individual? Did consumption of real water cause liver failure in plaintiff Keith Haley, who was one of the individuals before the court? So I'm going to skip ahead now. I went
So,
through.
and button that up for me, go back to it real quick.
Okay. And I do have some case law on that from Nevada.
No, but we'll get there. Button it up for me as far as the
Sure.
general versus, what are you saying as far as this expert is concerned vis-a-vis general causation?
So, Your Honor, this expert has expertise and degrees in epidemiology. So what he has explained his expertise is, and he said it in that quote that I showed you, he'll do things that are outside of what requires a license in medicine, but he cannot. So for instance, on general causation, he can look at statistics and he can say, here are these outbreak cases, the common thread is real water, perhaps that shows that there is some sort of issue here with this real water, hypothetically, that the real water could cause blank.
Okay.
But what he cannot do, and that's in that quote that I showed you, it's also in the published Georgia appellate decision, is he cannot make clinical diagnoses.
So you're saying he could testify as a general causation, but not as to specific causation?
Correct, Your Honor. So that he's the exact same as a biomechanical engineer. So if a biomechanical engineer can testify as to forces of an accident and
Nobody's
whatnot.
saying it, I get you.
Yeah.
That's not a good argument to make in front of me, because I don't think they can, I don't think the forces, as far as Delta V is concerned, are germane. I really don't. In fact, I think I tried the first biomechanical case in the state of Nevada. I really did.
Yeah.
Going way back to the early 90s, no one knew what it was. But I get you. I understand
Yeah.
what you're saying.
Yes, and
Without even using that, I understand 100% what you're saying.
the only distinction I was trying to draw there is general versus specific. So obviously, a biomechanical engineer, it's undisputed, cannot go to diagnoses of injuries and say medical causation.
I understand. I did. I did.
And the same is true here for Dr. Freeman. So if I could skip ahead now, and we've spoken about him not having a medical degree, that is undisputed. He himself says that he cannot do anything that requires a medical license here in the United States. And then I want to go on to our second ground, which still talks about, you'll see some more information about specific causation versus general causation. The key cases, Your Honor, are Holcomb and Wilson. Okay, and Wilson's on the next slide. And these are all briefed.
I understand.
The parties all cite the Holcomb case, even plaintiffs cite the Holcomb case, Your Honor, in the bench briefs. Holcomb explains that to prove causation in a toxic tort case, a plaintiff must show that the substance in question is capable, in general, that's general causation, causing an injury alleged, and also that exposure to the substance more likely than not causes injury. That's specific causation. That's Holcomb v. Georgia Pacific, that's 128 Nevada 614, it's a 2012 case. Now, Mr. Neal has previously explained to the court that's a asbestos and mesothelioma case, so there are, we believe, an even heightened, or I guess I would say relaxed burden of proving causation there, because there's some question of who provided the asbestos. But in any event, as a baseline here of what's applicable to the court, even Holcomb shows that there is this need for causation to prove both general causation and specific causation. Underneath that, obviously I cited the restatement of torts. I do believe that Nevada follows this provision. I know that for strict product liability it's different, but in any event, even the restatement explains that the
Well, they still
concepts.
follow it, just the second versus the third.
Absolutely.
Yeah.
The concepts of general causation and specific causation are widely accepted among courts confronting issues with toxic agents, end quote. That's at section 28 of the restatement third reports. Your Honor, the other case that we've mentioned to the court is Wilson v. Circus Circus. That's 101 Nevada 751, and it's a 1985 Nevada Supreme Court case. Quote, mere correlation between ingestion and illness is insufficient as a matter of law to establish causation. Now, that's an important principle, and Wilson explains it better than I ever could. But the principle explains that the mere fact that someone temporarily consumed a product, they suspected it might have been this tartar sauce that was tainted at the Circus Circus. But the mere fact that the individual consumed the tartar sauce and later got sick is not enough to prove causation. You actually need to prove both general causation, that this tartar sauce could have caused, it was capable of causing that illness, and also specific causation, that in that specific plaintiff, that more likely than not, that tartar sauce did cause that person's injuries. Now that involves a medical diagnosis, that involves a medical degree. Holcomb, this is another section of Holcomb, explains that mere exposure is not enough. To prove causation, it must be determined whether, quote, any of the exposures were a substantial factor in the contraction of the disease. This is getting to medical causation. Let me show you one more section of Holcomb. This is perhaps one of the most important parts in light of plaintiff's arguments in this case. So Mr. Kemp has stood before the court and argued that if any of these plaintiffs drank any real water, no matter the amount, and that if there's some suggestion that hydrazine is in some real water, that's enough and that, quote, his case is over and he's proven his case. That is not what Nevada law says. So, Your Honor, Holcomb v. Georgia Pacific, 128 Nevada 614 explains that Nevada does not follow the quote-unquote any exposure standard. So the quote-unquote any exposure is not enough. So again, this is a mesothelioma case, but it says, quote, in this case, neither party takes the position that some jurisdictions take that, quote, any, end quote, or, quote, each and every, end quote, exposure, even if it is just one strand of asbestos, is a substantial factor in causing mesothelioma. In fact, the courts that adopt the three-factor test of frequency, regularity, and proximity regularly reject the any exposure argument. And then the Nevada Supreme Court cites Lorman v. Pittsburgh Corning Court, 782 F. 2nd, 1156, the Fourth Circuit case from 1986, and it rejects the any rule as being contrary to Maryland's substantial causation law. The Supreme Court of Nevada also cited Gregg versus BJ Auto Parts, that's 596, Pennsylvania 274, 2007 case, and they quoted, we do not believe that it is a viable solution to indulge in a fiction that each and every exposure to asbestos, no matter how minimal in relation to other exposures, implicates a fact issue concerning substantial factor causation in every direct evidence case, end quote. And then the Nevada Supreme Court says, thus, more than any exposure must be shown. Thus, de minimis exposures are insufficient to prove that the exposure was a substantial factor in causing mesothelioma. Now, this demonstrates that Nevada follows the general causation, specific causation standard, and that to prove specific causation, and we're getting into kind of now the second ground for why Dr. Freeman needs to be excluded, at least in relation to his medical causation testimony for Keith Haley and Richard Belsky. And that's because he is...
So tell me this, though. I understand this any exposure issue and those types of things, but this is something I thought about as far as this case is concerned, because and we can all agree this case factually is slightly different, because the asbestos exposures can occur in a myriad of different ways. For example, you have men and women that I think one of the bases historically working in auto shops and changing brakes, brake pads and those types of things, or they could work at steel mills, or they could work in construction where they're like firefighters when homes are being destroyed and the asbestos. There's so many different factors there. But here's kind of my point. This case is slightly different in this regard, and maybe it's slightly different in a major respect, because one thing we know for sure is this, and this is what happened. The defendant, Real Water, manufactured Real Water, right? They were the manufacturer. And there's a lot of issues of fact, and even some that might be uncontroverted regarding their quality control and lack thereof. But who was in the best position to determine the hydrogen levels at the time of production? That's my question.
Well, Your Honor, I think that, the court is gonna say Real Water, and I don't think that that's necessarily untrue. I would note, and I think that you'll see this in.
Okay, but I mean, we can all agree, right? And why don't we know the hydrogen levels of Real Water at the time of production?
So this is what I was gonna say. So there, and I think you'll get testimony on this, and others will explain this better than I ever could, but I don't believe there was a viable test. They did testing on the water repeatedly for all sorts of toxins and bacteria, and they would do routine testing, but my understanding is that to test for hydrazine, it is an extremely complex test, and in fact, plaintiff's expert, who I deposed, Mr. Dooley, or Dr. Dooley, explained that he could not even test for hydrazine, and if he wanted to, it would take him at least 3 months to develop a test. So I think that's the reason why, but of course I don't want to speak for Real Water individuals.
Well, but that's, and so I'm kind of looking at it from that perspective, because, and we also know, based upon the expert testimony, that the hydrogen levels dissipate over time, right? We know that. And so my question is this a slightly different scenario? Because what you're asking the experts to do, like the expert, I think there's a motion pending to strike one of plaintiff's experts, and said, look, well, Judge, you can't give us a specific number or the quantity of hydrazine or whatever, but we do know it dissipates over time. But it was, it could be more or substantially more. That was just something like that. I was paraphrasing his testimony, but I was thinking about that. But at the end of the day, this is Real Water's product, right? So they didn't have, apparently, QC in place. Then the next, when I'm listening to what you said, well, Judge, this would be like a complex process to put something in place. Well, maybe if they're gonna sell Real Water and hydrogen is a potential byproduct, maybe they should have that in place. That's up to the experts. But my point is, who controls why there's no, with some form of particularity, any numbers as far as the Real Water and what levels, if any, hydrogen at the time of production?
Yes, Your Honor, and I would say that, Real Water probably is in the best position for that. The thing I would note is I don't think that bears on the specific causation requirement here, both under Holcomb, which we have here, but also Wilson v. Circus and the other case law. So the important thing for specific causation is that plaintiffs need to show that these individuals, so here for my clients, Keith Haley and Richard Belsky, they need to show that Keith Haley consumed enough of the alleged toxin, the hydrazine, in order to...
How can they show that?
Well, they can...
And that kind of circles back to my point. How can they show that?
They can attempt to calculate, or they could have attempted to calculate how much hydrazine he consumed, and showing that this amount of hydrazine is, according to their experts, more likely than not toxic in an individual, and this level of hydrazine would have, most probably would have caused liver failure in this individual. But, that's the one thing that Dr. Freeman does not do. So, if I could show you...
But isn't Real Water potentially using their failure to calculate or determine what the levels of potential toxins and or other things regarding Real Water as a shield at this point? Because they didn't do that.
I don't think so, Your Honor. So I do think that it's plaintiff's burden, to prove their case, and part of that proving the case for the specific causation requirement is to be able to show that these individuals consumed enough of the toxin. That's dose response case law. I know we've cited a lot of cases, including published decisions. The seminal one, which is McLean, that's in our both our motion and reply. But they need to be able to show that this individual consumed enough. Otherwise, the court is only requiring general causation, which is essentially that this Real Water could cause something, and then real water, and by default, my client becomes liable for every single individual regardless of the consumption of that specific individual.
Another question for you. What's the level of expert opinions regarding the quality control, quality assurance, and testing at the time of manufacture? What do they say?
I think that that's a very complex question. It depends on, for one thing, the facility you're talking about, so Desert Inn versus Henderson.
Wait, no. I'm looking at it from we're talking about product for human consumption, right? That's what we're talking about.
Yes.
And I know this will probably come, what do the QC experts, the quality assurance experts, say when it comes to product being manufactured and prepared for human consumption as to what should have happened at the point of production? What testing, if any, should have been done? And see, I don't know that.
For testing, so there's no standard or requirement at all for testing for hydrazine. So the QC experts, FDA, CDC, we deposed the Southern Nevada Health District. I asked the Southern Nevada Health District 30B6 witness directly, is there any requirement to test for hydrazine? Are you aware of any standard? And your Honor's probably familiar with, Nevada has bottled water standards. So for instance, certain things, arsenic and other compounds, including radioactive agents and whatnot, can be present in water up to a certain amount.
Okay.
There's a kind of presumption there that all water contains some sort of contaminant and whatnot, and that's actually what Southern Nevada Health District's environmental health specialist testified. She said, unfortunately, all water, including bottled water, includes some contaminants, so that's why Nevada has bottled water standards that includes cutoffs. And so, you're required to test for those things. Unfortunately, hydrazine is not one of those. So there is no set minimum level of hydrazine, and the other side of the coin is there's also...
Could it be because hydrazine should never be in water for human consumption?
So, Your Honor, the testimony in the case is that there is not a requirement to test for hydrazine because it was not believed to be one of a common type of compound that would be in water.
That's kind of my point. I mean, really. So, the fact, okay, I understand.
Yeah, the one piece of testimony, I guess, that I can recall, and others will know better, but from Dr. Goldsmith, which is Real Water's epidemiologist, he's the one that plaintiffs like so much. He explained that when he worked for the EPA, 15, 20 years ago, that he was tasked with trying to figure out, and there was some sort of spill on the California-Nevada border where hydrazine went in, they were worried that the hydrazine was in the water and whatnot, and he was trying to determine, what the level could be, and then he doesn't remember what they concluded. Other than that, I don't think there's any evidence in the case on, a requirement. There's certainly no evidence of a requirement for testing for hydrazine. And, there is no evidence of, a minimum.
I mean, for
allowable.
example, is there a requirement to test for radioactivity?
Yes, so the radioactive elements are on the Nevada bottled water standard. So you can have radioactive elements, there are very specific listed ones, and you can have up to a certain amount, parts per billion or parts per million of those.
But go ahead with this. I understand the distinction you're making.
Yeah, so, and Your Honor, and I think the key thing here, and this is Wilson v. Circus and Holcomb, is that you cannot just assume that based off general causation that a specific individual has been injured as a result. So just because something is capable of causing an injury in a certain way does not mean that happened with this plaintiff. So, I mean, obviously when you get to acute liver failure, and I know we've thrown that term around a lot, but there are many different ways that an individual could get acute liver failure, or have a liver injury. Obviously alcohol.
But I mean, there's many ways, but you can't put that in front of the jury unless there's evidence to support that. You can't say it could be this, could be that, could be this. You can't do that. And that's why, if you look at Nevada law, that's why I think Hardesty did a really good job with the independent alternative causation and plausibility there. Because before that, that's what would happen.
And Your Honor, there is testimony from experts on, other ways that some of these individuals got.
But there has to be a factual basis for that. There has
Yes,
to be
and
a foundation.
And
You
there
can't
was.
just make it up.
And there is, Your Honor, there is. So, I mean, for instance, some people, had high levels of, I believe, Tylenol was one of them, and that is known to cause liver failure. I believe there's one that, had certain supplements, turmeric or kratom, which is known to, are known to cause liver failure at certain quantities. So there will be testimony from experts on those. The key thing here for Dr. Freeman is he is not doing that. So he's not saying, and he cannot say, that these individuals had enough hydrazine or enough real water that contained hydrazine that would have caused liver failure. So I think, if I could flip what Your Honor said, you have to have a factual basis for medical causation, specific causation. And here, our second argument for Dr. Freeman is that he does not have that factual basis. Let me show you his alleged factual basis. So before, and these are his opinions for Richard Belsky and Keith Haley. And he is making a clear medical causation opinion here. And you'll see it says, it's my opinion that there's evidence to indicate that Mr. Belsky's hepatitis was likely due to a combination of factors, one of which was his repeated consumption of real water. Same thing with Keith Haley. He said, it is my opinion that there is evidence to indicate.
What was, were both hepatitis?
He says it for all of them.
Okay.
Yeah, so, Your Honor, this is, I guess I should, for the record, just state it. This is UNFW's motion. It's Exhibit B. This is his report, and this is page 35 of his report. So that's his comments or his opinion on Richard Belsky. And then his opinion on Keith Haley is on page 36, same exhibit, that's Exhibit B. He says, it is my opinion there is evidence to indicate that Haley's hepatitis was most likely due to a combination of factors, one of which was his repeated consumption of real water. Same exact opinion. Now, that is a medical causation opinion. That's a specific causation opinion. He is specifically saying that based off of his review, which we don't believe he's qualified to make, he's making a diagnosis, a medical diagnosis, that Keith Haley's hepatitis, which is liver failure, was most likely caused due to factors including his repeated consumption of real water. He does the exact same thing, making that medical diagnosis for Richard Belsky. Now, Your Honor, when he was asked at his deposition how he could say these things and on what basis he said these things and made this medical diagnosis, he could not offer any explanation. So his testimony was, okay, have you investigated what the effects of hydrazine are at various doses? He says, answer, no, I've not attempted to do that. Question, and again, thinking about hydrazine, when you were coming to your opinions about the 7 individuals in this case, what dose did you conclude would be necessary to cause each of their injuries? Answer, the dose they got. Then he's asked, how can you come to that conclusion? And here was his explanation, and I guess before I move on, that was our Exhibit C to the motion. That's his deposition transcript at page 28, lines 14 to 23. Then he's asked a couple pages later, how did you come to that conclusion? And he says, it's a quote, it's a little bit like asking how far does someone have to fall to die? Well, if someone is
I
dead from
remember seeing that
falling,
in the points of authorities.
it's as far as they fell. So you have to get reconstructed. That's at page 32, lines 7 to 10. Now I have his whole transcript if Your Honor wants to take a look at it, but throughout his testimony, he had no explanation for how he actually reached the threshold of the Holcomb case or the Wilson v. Circus case. What he is essentially testifying and admitting right here on page 32 of his deposition transcript is that he's using correlation. That's what Wilson says is mere correlation, and showing this kind of temporal analysis is not sufficient. So you can't just say because someone fell that, that was the issue. You can't say just because someone got sick after they consumed real water that their sickness had to come from real water. You actually, could get sick even if you consume real water. You could get sick from all sorts of different things, Tylenol, alcohol, whatnot. And I'm just saying those to the court. We're not going to throw out random ones to the jury. We're going to have ones that the experts say, occurred more likely than not. But Your Honor, here he cannot even do that with his own testimony. He cannot say, in terms of specific causation, that more likely than not, these individuals consumed enough real water, a dose of real water that was enough to cause their acute liver failure or hepatitis. So Your Honor, his medical
And I'm
causation,
sure concerned
Yeah.
with that, I realize it might not be as important for this motion, but why don't they test for hydrogen? Why isn't the state of Nevada or Clark County or whoever the entity might be, why don't they routinely test for hydrogen?
Your Honor, I certainly do not want to speak for Clark County or the state of Nevada or FDA or CDC or the others that don't have a hydrazine test, but my understanding from the depositions that I've been at is that, there are so many different compounds that can be in water. There are tons, and that it's not possible essentially to test for all of them. So my understanding of what they've done is select the ones that are most likely to be in water, the ones that, there's prior history of, these issues with certain things like arsenic and other things, these radioactive materials, and that is what's been included in, for instance, the Nevada bottled water standards or the FDA's guidelines or the federal regulations and the like. And hydrazine is not one of those for any of the standards.
Okay, I understand.
So, Your Honor, we believe that on 2 grounds, Dr. Freeman cannot provide this testimony about Keith Haley and Richard Belsky. He's not qualified, first
I got a
off.
question, is
Yeah.
hydrazine naturally occurring?
Yeah, so
Somebody,
I'm happy to answer, Your Honor.
did I hit an important point, sir? I just want to know, is that naturally occurring?
I honestly think with regard to these questions, and I'm sorry to interrupt.
Yeah.
Mr. Hoffman on this. There's a chemist that we've retained that can answer these questions.
Okay, I understand.
These questions that you're asking are the right questions. I don't know that they're the right questions for this particular
I understand.
motion. They are for you, and so that's why it's important, but I think maybe if you want to, we can certainly do an evidentiary hearing. You can ask the questions.
No, we don't need.
But the answer to
I don't have time for evidentiary hearing.
I didn't think so. The answer to your question is no. You can't go to a plant and find this hydrazine. It's a synthesized material. It requires hydrogen to be to not be available to work at a chemical level. Remember, hydrazine is chemically N2H4.
I understand.
Ammonia,
I get it.
similar to that, which we use every day in bleach and other things like that for cleaning purposes, is NH3. That's the common place that you find something similar to this. Then we add 1 atom of nitrogen and 1 atom of hydrogen, and we get this. But in order to get that molecule to happen, it's synthesized. It has to be made. And our Southern Nevada Water Authority does not test for this because it's something that has to be man-made and you'd have to go find it. There is equipment, it is expensive, but it's available on the market to be able to find it, and we have an expert report on this that the court will be seeing at the time of trial.
I got you.
So, Your Honor, I think to be clear on this one, I do think this is a disputed issue, and I do think I've seen testimony in the case explaining from the federal government that algae, for instance, can synthesize hydrazine naturally. So I do think that there's now I'm not saying that plaintiffs are alleging that in this case,
No,
but
no.
Yeah.
But see, this is, I don't mind saying it, as a trial judge, we switch gears so many times. I mean, for example, I don't even know if I came out of trial before this one, we've been so busy. But each case presents different challenges. And as I get more familiar with what the facts and the medicine and the science might be, I start asking questions and start digging a little deeper, and I get a chance to, and I don't mind saying this too, that's why I'm a big proponent of pretrial motions. I'm a big proponent of, I don't believe in a meet and confer, although it's required, because this is when I truly get educated on the case, right? For example, is it a naturally occurring substance, right? And I appreciate you saying that's a good question, but these are things I need to know, right? And I just do, and get really educated on the facts. And I can't do this a week before trial, and just as important too, I don't want to rush. I don't mind saying it. I want to dig a little deeper and think about it, and sometimes I have questions that are or issues I have to decide as that might be considered first impression, like as far as similar events, what I call it. I don't really think it's a first impression. I just cobbled together what I thought the impacts of Kraus and maybe Harley Davidson might be as far as similar events are concerned. That's all. And added a few little touches. But what we're gonna do, I'm gonna let you finish up whenever you're ready, and then we'll go to lunch.
Okay, and I'm ready, so, so Your Honor, Dr. Freeman has also been routinely excluded by courts, and I'll flip through them, and I'll grant you, some of them are not published, they are federal judges, federal opinions.
The only problem, and I'm like telling you this, the
Yeah.
problem with federal is they follow the Daubert standard, right? Trust me, I get this. It's a slightly difference. I mean, it looks at, and I think what Mr. Odou was saying, Judge, when I was bringing up the gatekeeper issue, I wasn't really talking about Hallmark. That's a general role of the trial judge, which it is, right? And I think everyone agrees, but the Daubert standards are slightly different. But in Hallmark, they said you can kind of look to it a little bit.
Persuasive.
Yes, there is.
Persuasive. Your Honor, so just to go through quickly, so Dr. Freeman did not determine how much hydrazine Haley or Belsky would have needed to consume to suffer a liver injury. That's number one. Freeman did not attempt to determine whether they actually consumed that amount of hydrazine. Freeman admittedly assumed that because Haley and Belsky likely consumed some hydrazine and later suffered from a liver injury, it must have been caused by hydrazine. That's a temporal, what I'll refer to as a post hoc, proctor ergo hoc opinion. That's, because of this that happened, therefore that. That's what's not allowed.
But why can't, doctors do that all the time based upon differential diagnosis, right? They can. I'm just talking about doctors. Like, for example, that statement, they could look at the medical history and go through step by step and say, hey, if you got hydrazine exposure, I think this caused the liver injury, right? They do that.
They would need to show that that individual consumed enough of that hydrazine in order to cause liver injury. But if that wasn't the differential, then yes, then they could eliminate other causes.
They do that every day.
But he skipped that. And I'd also note the big underlying issue here, the big elephant in the room, is that he's not a doctor. So he can't do that medical diagnosis, differential diagnosis anyway. So he admittedly assumed that he did basically this temporal causation argument. And this temporal causation testimony is speculative, unreliable, and of no assistance to the trier of fact. That's directly Hallmark 124 Nevada at 502. And I'll flip through these quickly. But Dr. Freeman has been routinely excluded on both of these grounds. He's been routinely excluded by courts, including a published case from the Appellate Court of Georgia, that he cannot testify. He's unqualified to testify on medical causation issues. He cannot give medical diagnoses. And he's also been routinely, I'm talking about 5+ opinions, where he's routinely excluded for giving his exact temporal causation testimony because it's unreliable and it's of no assistance to the trier of fact. So yes, this is an unpublished decision. This is Andrews versus Crowell. I won't even read the site. It's in our papers. Next one, Deathridge versus Schindler Elevator Corp. This is a District of Nevada case from 2018. The court will grant the motion because Freeman did not reliably apply his methodology. Rather than ruling out specific events that could have caused Deathridge's injuries, Freeman simply opined that it was unlikely Deathridge would have received injuries from anything other than the elevator's abrupt stop. Accordingly, Schindler's motion eliminates to exclude opinion testimony of Michael Freeman will be granted.
Was this appealed?
This is a federal District of Nevada case. I don't believe it was appealed.
But that's the reason why I don't look at this stuff. There's another district court. I'm not going to. Because I don't mind telling you this, I don't always agree with the federal judges. I think actually, in fact, some of the lawyers here might remember this. I remember I had a companion case in Wurzbach, and which was moved to federal court. I kept in Rekitek, and they had a lot of difficulty with Wurzbach. Didn't they went up to 9th Circuit 3 times and they were reversed 3 times, whereas I had no problem with Rekitek. And that's kind of my point. And then they bring a judge in from Wyoming to finish that case up.
That's right, Judge Jones was, I won't call him difficult, but he had a different view than most judges had of the case.
Right.
So they brought in the judge, what her name is.
From Wyoming,
Yeah,
right?
she's from
So-
Wyoming.
Yeah.
We were on opposite sides of that case.
Oh, I understand. You guys were all fighting on that case, Mr. Parker. I think you tried one of the subclasses in this department.
Yeah, that was the Upinor.
Yeah, right. But that's kind of my point. Trust me, I respect all the federal judges, but they don't deal with state law issues, and it's not their fault, really. They don't deal with state law issues all the time. They hadn't, I mean, I was dealing with chapter 40 every day. It was new to them, right? Yeah, 3 times a day, right, Mr. Odou? And that's
Agreed,
kind of my
agreed.
point, right? But, and so it's nuanced, and I could see where a federal judge looking at it for the first time might have some problems, because chapter 40 was pretty sophisticated. Does everybody agree on that?
Agreed.
Yeah.
Yes.
And Your Honor, I don't mean to suggest that you in any way need these cases to reach the decision that we're proposing. Obviously, we think Hallmark and Williams are very clear in that
I understand.
Dr. Freeman does not satisfy those standards. I'm merely showing the court, and I'm trying to show for the record that Dr. Freeman is routinely, and I'm talking about 5+ times for each of these grounds, he's routinely excluded by judges across the country for both of these grounds. Here's another one, In Re Deepwater Horizon. Again, this is, I'll admit, this is unpublished, it's Northern District of Florida, but again, this last year, 2022, quote, Dr. Freeman does not describe a threshold dose of a chemical which is capable of causing plaintiff's LMPCs. This latter failure is fatal to the admissibility of the opinion, as case law requires plaintiffs to present at least a threshold range of exposure which is considered capable of causing a chronic condition. And I only show this to the court because this is persuasive authority according to Hallmark, and I do think it's
No, it's
right
not
up.
persuasive authority. I mean, really and truly, it's in violation of Nevada rules of professional responsibility as far as what cases can be cited, right? And I forget the rule, but and you know what, and I don't think it's the Nevada appellate rules, I'm sorry. You know, not I want to make sure, yeah, you can't cite them for any purpose other than.
In the appeals court.
Right, you got it, you know what it is.
Yes, and you know, again, I'll say this again just for the record, I'm only showing this to show how many times Dr. Freeman is excluded and how he's routinely excluded for these things. The last one is from Judge Escobar here in this courthouse, and in this Perez versus Alley case ruled under Hallmark. Moreover, as in Hallmark, Dr. Freeman's opinion is highly speculative because he has only limited knowledge of the actual facts of the accident and the forces involved. Dr. Freeman's opinion on causation is thus not helpful to the jury and will be excluded, end quote.
I understand.
So Your Honor, you know, I only give those, I want to emphasize and be very clear. Under Hallmark and Williams, the cases, you know, those are the only 2 cases that, you know, Your Honor needs to consider. I know Your Honor knows them well. Freeman does not satisfy them for either his qualifications, because he is not a medical doctor, he's not allowed to practice medicine in the United States, and he has no clinical experience whatsoever that would allow him to make medical diagnoses. And he also is not allowed to provide his specific causation opinions about Keith Haley and Richard Belsky, because they are speculative, unreliable, and of no assistance to the trier of fact, because they merely assume specific causation based off this temporal argument. Thank you, Your Honor.
Thank you, sir. And what do you think, 1:30?
That works, thank you.
All right.
All right.
Court 16 is now in session. I'll Mr. Lewis presiding. Please be seated.
All right, we're back on the record, and let's go ahead and set forth our appearances. We'll start first with the plaintiff, and then to the plaintiffs.
Good afternoon, Your Honor. Jim Neal with my colleagues Nicholas Hoffman and David Spurlock on behalf of UNFI.
Good afternoon, Your Honor. Joel Odou and Matthew Kaufman on behalf of Rural Water Inc. and Judicial District Court.
We're going to Scott Rasmussen on behalf of Hanna Instruments.
Good afternoon, Rob Robbins from Milwaukee.
Good afternoon, Your Honor. Jim Kavanaugh for Real Water, Tennessee, LLC.
Okay, once again, good afternoon. I guess we're going to continue on with this motion. I know we had some joiners. Is that correct?
Yes, Your Honor. Joel Odou on behalf of Rural Water. We have joined, and I don't have anything to add to the comments of counsel that's already been made.
Thank you, sir. Any others?
And then also, Joe, we don't need to bring any evidence at this time.
Well,
Thank
we
you.
have a pretty rigorous, robust
We'll
record.
have some time later.
Yes, I understand. Okay, we'll go to the plaintiff for the opposition.
Thank you, Your Honor. Eric Pepperman for plaintiffs.
So, prepared for the opposition for today, and the argument and comments from Your Honor.
Tell me about this degree. I mean, I'm trying, number one, I need to know a little bit about the qualifications.
Well, Your Honor, in a nutshell, in terms of his medical degree and qualifications, Dr. Freeman has a Doctor of Medicine degree from Umea University. I think I'm pronouncing that right. Umea University is a foreign medical school that has been approved by the Medical Board of California. I think Your Honor referenced that in your own independent research. It's a recognized medical school. Graduating from there, along with any other applicable requirements, is sufficient.
What is his degree? I mean, I don't understand his degree. I mean, what is it?
It's a Doctor of Medicine degree from Umea University.
Now, I do know this because I was curious, and one of the things I try to do is not prejudge other academic institutions because, for example, we got a lot of physicians that come from Pakistan, India, and all these places that are well-trained in Europe and South Africa, and so on and so on. And that's why I said, okay, Umea, I never heard of it, but that doesn't mean it's not a viable institution. Just as important, they're from Sweden, right, Scandinavia, and so on, and so I thought about that. In fact, I'll keep it even, we have doctors from South America, I mean, everywhere, right? And I understand that, and so I'm trying to figure out specifically, what does that degree do, what are they qualified to do, so on and so on, and
Well, Your Honor, I understand the question, and this hasn't been an area that was explored, but my understanding is that it's a foreign medical school that is approved as a school where, at least by the Medical Board of California. Now, I think I'm not sure about the additional requirements after the degree beyond that in order to qualify for a medical license in any state such as California. It's my understanding that there would be additional requirements that Dr. Freeman would need before he was able to become a licensed medical doctor in the
well, you know,
United
of course
States.
you'd have to pass the board test. I mean, I get it, probably.
Yes, and I don't want to speak to those
But I don't
requirements.
know. I don't know.
And Your Honor, I don't know that it matters because he's not a licensed or practicing medical doctor. He doesn't do any work that requires a medical license. And it's hard to fault anyone for choosing not to practice medicine in this day and age. He has a medical education, a doctor of medicine degree from a well-known and qualified university in a foreign country. He uses that education to teach, to conduct research, to publish. He's a medical scientist. He doesn't treat patients. And that has nothing to do with his qualifications to give the opinions that he offers in this particular case. And I do think that's a very important distinction because the facts of the case matter, what he's doing. And we know that from the Williams case where the Supreme Court said, look, there's no bright line rule in terms of whether you can give a medical causation opinion, contemplating that a nurse under the right facts and circumstances could be qualified to give an admissible medical opinion. So in addition to...
Well, I mean, I think that's what Justice Hardesty did at the very end of the case. I do remember that, you know, where he, and I think he looked at, and it's been a long time, I thought it was Tennessee, I could be wrong about that.
I do believe it was the Tennessee case that he referenced as an example. And,
yes.
But separate and apart from Dr. Freeman's medical education, his training, his research and expertise, Dr. Freeman is also a highly qualified epidemiologist. Chris, can you pull up the page 2 of the initial report? This is,
And I have it right in front of me. actually.
his qualifications are recounted in the briefing, and you have the exhibit, but just to, kind of go through some of this stuff. He's a fellow of the Royal College of Pathologists and fellow of the Faculty of Forensic and Legal Medicine of the Royal College of Physicians in the UK. He's a member of the British Association of Forensic Medicine. He holds degrees, a Doctor of Medicine from UMEA University, a Doctor of Philosophy, PhD in Public Health Epidemiology from Oregon State, a Master's of Public Health and Epidemiology and Biostatistics, also from Oregon State, a master's degree in Forensic Medical Sciences with the Academy of Forensic Medical Sciences in the United Kingdom. He's completed a 2-year postdoctoral fellowship in forensic pathology at UMEA University. He holds a diploma of legal medicine with the FFLM. He's a fellow of both the American Academy of Forensic Scientists and the American College of Epidemiology. He's a Fulbright Fellow, 3-year roster appointment with the U.S. Department of State as a Fulbright Specialist in the field of forensic medicine. He's served as a tenured Associate Professor for Forensic Medicine and Epidemiology at a foreign university, and a Joint Clinical Professor of Psychiatry and Public Health and Preventative Medicine at Oregon Health and Science University School of Medicine. He's taught courses for the past more than 20 years in forensic medicine and forensic epidemiology. For 12 years, up till 2017, he held an appointment as an adjunct professor of forensic medicine and epidemiology at the Institute of Forensic Medicine, Faculty of Health Sciences in Denmark University. And he's a recent visiting professor at University of Indonesia in the Faculty of Medicine. He's an associate editor of Journal of Forensic and Legal Medicine, and he served as an associate editor or editorial board member of an additional 14 scientific peer-reviewed journals. He's published approximately 230 scientific papers, abstracts, book chapters, and books, including text for the main practice guides in forensic epidemiology. His work's been cited, thousands of times, and he's regularly been qualified to give expert testimony in hundreds of civil and criminal trials. So when you look at his qualifications as a whole, he's a highly qualified epidemiological and medical expert to testify to his opinions under the facts of this case. Defendants ignore all these qualifications and assert that Dr. Freeman cannot give any individual causation opinions or specific causation opinions unless he is a licensed medical doctor. Of course, they cite to no Nevada precedent for this. They only cite to several unpublished federal district court cases applying the Daubert standard, which does not govern admissibility in Nevada. And those cases are all under inopposite facts to boot. A few of them were before Dr. Freeman even received his medical doctorate degree. Hallmark, as Your Honor noted at the outset, is the guiding standard in this state. And what Hallmark says in terms of qualifications is you look at several factors, including formal schooling and academic degrees. Licensure is one of them. Employment experience and practical experience and specialized training. Quote, we note that these factors are not exhaustive, may be accorded varying weights, and may not be equally applicable in every case. And that's the point, Your Honor. These are fact-specific inquiries where you have to look at the facts before the court. Licensure, this standard, this test, you have to be a licensed medical doctor, is false. Licensure is one non-exhaustive factor to consider in light of the facts of the case. It may not apply under the facts of the case, and it doesn't apply under the facts of this case, which is primarily based on epidemiological evidence, probability of causative factors, and inferences from that evidence. And just to be clear for the record, and we cite this in our opposition, the cases where the Nevada Supreme Court has repeatedly held, quote, an expert witness need not be licensed to testify as an expert as long as he or she possesses special knowledge, training, and education. That's the Fernandez Fernandez v. Admiral, 108 Nevada 963. And then we also cite the Wright v. Las Vegas Hacienda case, 102 Nevada 261. Quote, a witness need not be licensed to practice in a given field to be qualified to testify as an expert under Nevada standard. So that's the relevant question here, not licensure. Does Dr. Freeman possess the special knowledge, training, and education necessary to give the opinions that he offers under the facts of this case? So let's talk about that, Your Honor. That goes to the assistance factor, and is it relevant and the product of reliable methodology? You were given some arguments and think some quotations from Dr. Freeman's deposition out of context regarding that, he can't give his opinions, he can't assist the jury because he can't say that the individuals drank enough hydrazine to make people sick, he doesn't know the dose they got, and that he's just speculating about all this stuff. Well, that is just not true. And first, there's been a lot of comments on this that I think Your Honor has made some comments to suggest that you understand it, but just to be clear, there's no requirement for us to prove hydrazine caused the injuries in this case. The causation requirement is that the real water product was defective and unreasonably dangerous, and the real water caused the injuries in this case. Now, it's obvious that real water was riddled with hydrazine, all real water was riddled with hydrazine, and that's certainly compelling evidence to explain what happened here and to support the claims in this case. But in terms of requiring any specific defect, that is not a requirement under Nevada law. So I do think that's important. And when we talk about...
you need to explain why the product is defective.
We have to explain that the product was defective, more dangerous than the ordinary consumer would expect.
A defective product can reasonably be dangerous pursuant to the statement of torch laws.
Correct. That's what we have to prove. And that could be proven by a lot of different ways. Certainly the factual evidence that this water was riddled with hydrazine makes that proof a lot easier. But all we have to prove is that they were exposed to real water and that the real water caused their injury. That it was unreasonably dangerous, and you drank real water and you got sick from it. If we couldn't prove the exact toxin in there, we would still be able to prove the case, because that's pretty common in outbreak cases like this, where you don't know exactly what was in there. Fortunately, in this case, we have substantial evidence. We were able to, with the FDA testing and the evidence of the manufacturing process and the problems going back years and years, it's a much easier case, but it's not uncommon that outbreak cases are proven all the time without really being able to identify the specific substance. And the substantial evidence that real water was problematic here goes back to the Southern Nevada Health District epidemiological investigation. And I do think it's important to go through just some of this stuff so you have an idea of what's going on here, that it's Dr. Freeman's not coming in and saying, well, they drank real water, and so real water must have been it. Chris, can you pull up the MMWR article And just the first paragraph, if you can. If Your Honor recalls, we've gone through this first paragraph, or this document before, and this all started with the 5 kids who were Flight for Life to Children's Pediatric Hospital in Salt Lake City. That prompted a report to the CDC and an investigation. And what did the initial epidemiological investigation involve? A review of the kids' medical records and interviews of their parents to identify common exposure. They identified real water as the only common exposure, and based on that, the Southern Nevada Health District, CDC, and FDA launched a public health investigation. If you can go to the second paragraph, please, Chris. So the Southern Nevada Health District did the epidemiological investigation, and based on the 5 kids and their household interviews, the Southern Nevada Health District, first thing they did was they developed a case definition. And you asked about this case definition before. They basically said, all right, a probable case of liver illness associated with real water consumption included 3 criteria. The first one was an illness onset date on or after August 1st, 2020. They set that date because that was the earliest injury in the households of the 5 kids. That was Chris Red. The second is documentation of a negative viral hepatitis panel and hepatic imaging that did not reveal a cause, meaning if you have hepatitis, the first thing is it viral? If it's not viral, if we don't have a cause, then it's something else and potentially associated with real water. The third was no documentation of another cause. So what they're doing with the epidemiological evidence is saying, okay, we have an epidemiological link with real water. They don't know that it's hydrazine. They don't know what's in it. They just know that it's causing liver failure in commonly exposed people. And if you're drinking real water and you're suffering liver failure and you don't have, it's not viral hepatitis and there's no apparent cause in anything, that's pretty strong evidence to associate the cause as real water. So that's what they do. They set out to find cases. So after setting the case definition, the next thing they did was they issued public notices, calls for cases. And just a couple of these. If you can, Chris, pull up the health advisory notice. There's 2 of them, the Southern Nevada Health District one and the CDC one. You want them both? Yeah, I just wanted them in there, just to show. So this is the Southern Nevada Health District one. They're basically given a public notice to say, hey, we've identified this link between real water and liver failure. And if it goes to clinicians and the public, if this happened to you or if you have a patient like this, let us know. We're investigating it. So they send out these public notices. And as the MMWR article states, that these cases, possible cases, were mainly identified through self-reports and clinician reports. So all they're doing is saying, hey, we've identified this link. If this happened to you or one of your patients, let us know and we'll investigate. So that's what happens. They start getting calls from people saying, hey, I was a real water customer and I suffered a liver failure or a liver injury. And then they would interview those people and they would look at the 3 criteria as part of their investigation. Was your illness onset after August 1st, 2020? If no, sorry, you're not a case. You don't meet our definition. We're not even going to further investigate. Number 2, if you're, did you have imaging done? Is it viral? Oh, no, it's not viral. Okay, number 3, let's look at your medical records. Is there any other causes for this? No other causes. Okay, you're a probable case. That's what they did. They looked at what the people said about their exposures. They looked at their medical records, and they excluded other possible causes, and they narrowed it down to real water. That's a differential diagnosis, exactly like Your Honor said. It's done in the epidemiological setting, it's done in the medical clinician setting, and it was done in this setting. So, Chris, if you can pull up the PowerPoint pages from the PowerPoint presentation. So during the course of this, afterwards, after the, during the investigation and after, the CDC, Southern Nevada Health District, they were going around and they were giving presentations at conferences about what happened, the outbreak, and what their investigation entailed. And so I have some pages from this to kind of help the court understand and see, generally an overview of what was going on. So this is it, the PowerPoints from the CDC. This was given in December 2021. Go to the next page, Chris. They're talking about their investigation. Next page. This is the reference to the initial report from Las Vegas kids going to the hospital in Utah. Next one. They describe it. We review medical records, see what's going on, any alternative causes. Next one. They did an exposure assessment. What are these people exposed to? Is there any explanation for these liver failures? Next page. This is a summary of the cases by month that they identified. And again, Your Honor, this was all done without any knowledge of the FDA testing, without any mention of hydrazine being the cause. This was just based off real water. And so they identified all these cases, the 21 probable and 4 suspect cases associated with real water. And I think one other important point on this is that a lot of the cases, the majority of them, were after the super bad batch. But they found cases associated with real water as far back as they looked. And that's why this whole Chris Wren issue has been raised over and over again, because he was one of the probable cases in August, before the Henderson move, before Casey Aiken mixed the super bad batch. So you have this problem in all the real water. It's just when you add more concentrate or hydrazine to the water, like Casey Aiken did, a lot more, then you see the spike go up. Next page. This is the common symptoms and signs and symptoms that were self-reported by most people, and Mr. Kemp showed you another chart, going beyond this, but we have nausea and vomiting, signs and symptoms of liver disease, dizziness, weight loss, vision problems. So I think that, goes to a lot of the, well, I'll get there in a second. Next page. This is a list of potential toxins that they were considering as part of the investigation. I would note that hydrazine is on this list. I think this is important too, because there are limited causes of toxic liver failure. They're not, it's not something that happens just naturally. It's not like cancer. You can't compare it to cancer, where someone can develop cancer for unknown reasons that have nothing to do with any type of medication or substance that they may be exposed to. So in a cancer causation case, you may have something a little bit different and may have issues and questions regarding the need for medical clinician expert testimony in different standards of admissibility than you would have in a case like this, where you're talking about an extremely rare disease, toxic liver failure and a limited universe of potential causes for that. That lends itself to a probability analysis, inferences based on exposure. Next page, Chris. This is the query diagnostic codes. This is what the Southern Nevada Health District did was when they did a search of all Clark County hospital discharge documents with an ICD diagnosis code of toxic liver disease or hepatic failure not elsewhere classified. Again, they excluded other diagnoses of liver failure with identifiable causes. Next page. Next two pages are the charts based on that. We can go to the next page, please. Okay. This is the case control study. Now, I'll explain in a minute, but to avoid any argument about this, they didn't do a formal case control study. This was a similar to a case control study, what they do in epidemiological fields to identify an odds ratio, which is a quantification of a statistical significance of association between two events. In this case, exposed to real water, suffer liver failure. Next page, please, Chris. So what they did was they identified with their ICD query all the cases of toxic liver failure, unexplained etiology in Clark County between April and December, the period under review. Okay, they identified 56 patients with that with their proper diagnosis. Next page, please. Okay. This is the general explanation of what they're doing. They're identifying a number of cases. Out of those cases, who was exposed to real water, who wasn't, and then they have an area for the controls, and they explain how they calculate an odds ratio. Okay, next page. So what they did was they found 56 cases of non-viral hepatitis with no explained etiology. 14 of them they identified as being exposed to real water. 42, they had no evidence that they were exposed to real water. Okay, so next page, please. So this is what they did for the controls. Now this is why it wasn't a formal case control study, because they just estimated the controls. So they did two different estimates. The first one they estimated, in terms of the control, they're trying to determine, all right, how many people use real water. And so they estimated in the first one based on the 5-gallon customers. So 100 known 5-gallon customers with an average of 2.8 average household size. So that gave them a 280. So 14 out of 56, with 280 assumed customers out of almost 2.2 million people in Clark County, you get an odds ratio of 2,619. Okay, that's, is beyond statistically significant, but we don't even need to use that one. This one, the next one, was assume 1% controls exposed. 1% of the population of Clark County, they assumed, were drinking real water, which is a way overestimate. So even based on that assumption, they came up with an odds ratio of 33, which is substantial evidence of causation of real water. Again, they didn't know, hydrazine at the time. Real quick, I just want to go to Dr. Zhang's testimony excerpt, Chris, and we'll come back to this one. You can go to page 71, line 18. This is Dr. Zhang explaining why they didn't do the formal case control study. She said, so we estimated the scenario because it is logistics and not feasible to find that many controls and to interview every single one of them for their real water consumption. It was not feasibly possible for them to go interview everyone in Clark County to say, hey, are you a real water customer? So they just estimated 1%. Quote, so we estimated the range of odds ratio based upon the hypothetical scenario. For example, assuming 1% of Clark County residents consume real water, that would give us the control of 22,000, which is a very conservative estimate. The actual real water consumer would be less than that number. But based on this conservative number for estimate, we still arrive at the odds ratio of 33. So we decided it is not worthwhile to invest our staff time as well as resources to get the real water number. In other words, based on a conservative estimate of way more actual real water consumers in Clark County, they came up with such a strong, statistically significant odds ratio that they just didn't want to waste their time and resources trying to say, oh, what's the true control number for an odds ratio associated with real water and the toxic liver failure that was under review. So in reality, it's probably way higher than 33, something more than the 2,600 and whatever based on the 280 estimate, but way more than 33. So strong evidence of causation there. We can go back. Okay, next slide on this one. So what else did they do as part of their investigation? They did what's called a household severity study based on the information that they had. So based on the probable cases and estimated cases and household members, they broke it down based on hospitalization, sickness without hospitalization, and not affected household members. We go to the conclusion page, it's a separate. The household severity study conclusion.
Where's that? I only have till here.
It's not on this, it's a different document. So based on their investigation, they determined that for every additional 1 milliliter per kilogram a day of real water consumed, the odds of being hospitalized increased 11%. Okay. 1 kilogram equals 2.2 pounds. So if you take a 25-pound child, for example, that's 10 milliliters a day. That child's odds of being hospitalized goes up 11%. Hospitalized with liver failure from drinking real water. If you take a 200-pound adult, I didn't do the math on that, but still, we're talking a liter a day is associated with the 11% increase of hospitalization with liver failure based on the Southern Nevada Health District's epidemiological investigation. Can you pull up the opposition, please, Chris? Page 15. You can blow up the quoted language. This is Dr. Freeman's opinion with respect to Mr. Haley-Belsky. As detailed in my prior report, the frequency of toxic hepatitis is exceedingly low. Given the evidence, including but not limited to the reported frequency of toxic hepatitis associated with real water consumption, the additional evidence that all real water products likely contain hydrazine, the identified literature related to the hepatotoxic effects of hydrazine exposure, and the remote competing risk of the illness due to any other known factors, it is my opinion that the most probable explanation for the hepatitis illness experienced by Mr. Belsky and Mr. Haley was their consumption of real water, which was most likely contaminated with hydrazine. That's Dr. Freeman's opinion. It's not based on, oh, well, he just drank it. It's based on his review of the epidemiological investigation and the scientific research on hydrazine toxicity, on his review of the plaintiff's medical records, his review of the alternative exposures, his review of the literature related to the competing risk of alternative exposures, and a significant amount of other information. That's what Southern Nevada Health District epidemiologists did with respect to determining their probable cases. That's what Dr. Goldsmith did. Real Water's epidemiologist with respect to developing his opinions that the obvious explanation for these liver failures in these plaintiffs was exposure to hydrazine. And the other competing risk factors don't provide any plausible explanation. And that's what Dr. Freeman did. And Dr. Freeman did that as based on his epidemiological expertise, based on his medical education, training, scientific research, based on his education and training overall. He is plainly qualified to give these opinions, and they are not, as defense counsel suggests, based on some speculative assumption that, oh, well, they drank real water at one point, so they must, it must be the cause. No, it's based on scientific evidence, scientific expertise, knowledge, skills. These are well qualified and admissible opinions. Now, I think there's a couple other important things to address that the court previously raised. I think defense counsel argued that to prove this case, we have to identify how much hydrazine exactly every plaintiff was exposed to. And Your Honor, I hit the nail on the head. He said, how? How do you prove that? And he gave the game away. Oh, they should have calculated it. They should have back calculated it. Well, it's not possible, Your Honor. They're setting this fake, impossible standard. It's the ultimate straw man. Oh, they have to prove how much hydrazine they were exposed to. That's not possible, so we can't prove our case. That's not the standard of proof. It's not the standard of admissibility. It's not any standard whatsoever except a made-up standard that they are advocating. There's no basis in the law for it. I think Your Honor understands this point. You called it right. Well, what about real water? They're making the product. They're putting it out on the market without any testing to determine it's safe. They're ignoring repeated customer complaints. Your water's making you sick. There's, chemical smell in it. That's what our case is, Your Honor. This water had chemicals in it that made people sick. I mean, what more can we do besides that? The evidence that all this water was riddled with hydrazine from the beginning is overwhelming. It starts with John Marlowe, who says his guinea pig method. Oh, I would add concentrate, and it would make me sick, so I would add a little bit less to figure out the formula here. He didn't understand what these titanium tubes were. He couldn't explain what they did. They're applying massive amounts of voltage to electrolysis to this. They're adding chemicals together that they don't understand. They're creating rocket fuel in the water. And then they're saying, oh, well, you can't prove that the rocket fuel made you sick because you can't say if it was X milliliters or Y milliliters. I mean, and then they seek to exclude every expert on it. It's another thing that Your Honor observed. You called them out on that too. Well, they're trying to exclude every expert, saying you can't, you don't know how much hydrazine was in there. Well, yeah, we don't have the water that existed at the time. You can't back calculate how much it was. But we have plenty of evidence that this water was always riddled with hydrazine, been making people sick. It makes people sick at a rate of 1 milliliter per kilogram a day. It increases the chance of hospitalization by 11%. 21 probable cases based on a very limited number of self-reports. Most of the plaintiffs in these cases were not part of the Southern Nevada Health District epidemiological investigation. Many people reported illnesses with an onset of prior to August 1st, 2020, and they weren't investigated or they were automatically excluded from the investigation. You still, based on that limited number, found a conservative odds ratio of 33. So the evidence is overwhelming. Dr. Freeman is well qualified to interpret the evidence, rely on the evidence, and draw inferences from that evidence. And defendants are free to cross-examine him on, the propriety of a medical degree in Sweden versus a U.S. institution, or the fact that he, does scientific research and publishes and gives testimony in legal cases instead of acting as a practicing clinician. But those go to weight. They don't render his well-qualified opinions inadmissible. So for all those reasons, we ask the court to deny the motion.
Thank you, sir.